Okay, so we will start now with our second keynote presentation for the conference, and we are very pleased to have with us Chinmayi Arun, who is an assistant professor at of law at the National Law University of Delhi, where she is also the executive director of the Center for Communication Governance. Chinmayi has studied at the NALSAR University of Law and also at the London School of Economics and Political Science. She has taught in numerous places, including in the West Bengal National University of Juridical Science, and she is she teaches a course on information policy and internet governance at National Law University of Delhi. We're very pleased that you are here with us. You've just arrived from the airport, so we very much appreciate this. And the presentation title, as you can see, is Artificial Intelligence, Algorithms and Speech, Setting Standards for the New World. You have the floor.
Thank you so much. Thank you for having me. It's such a pleasure being here. I hope you'll forgive my sitting down. I'm not a fan of just the straight up lecture, so I've got I like to have my notes on hand, but honestly, if you feel like interrupting me and having conversations in the middle, please feel free to do so, because I'm usually all about the inverted classroom. It's the post-lunch session, so I know you're not going to need my permission to sleep if you need to. However, just as incentive, I want to let you know that there are pictures of cats and a few videos in there. I'm not much of a slides person, so there'll be a little bit, but you know, all of my information is not concentrated on slides. And like I said, I'm happy to sort of go off on a tangent, because as you can see, this is a really broad brush topic, and I'm choosing to cut it in particular ways, but I'm aware that there are very different takes that you can take on this. So I'm going to begin with basically this, which is a very recent incident. It happened 2 weeks ago. But I feel like it illustrates beautifully why this topic matters at all. Just in the interest of full disclosure, I chose the subject very long ago, long before Mark Zuckerberg came up with this. This is just him being generous to me. So I'm sure that several of you have heard of this. This is Zuckerberg's basically, he's announced a new thing that Facebook is going to do. He says that it's going to start scanning for the likelihood of suicide. And you can see he's put up this really touching post introducing what they're planning to do. Here's a good use of AI, by the way, AI for good, helping prevent suicide. Starting today, we are upgrading our AI tools to identify when someone is expressing thoughts about suicide on Facebook, so that we can help them get the support that they need quickly. In the last month alone, these AI tools have helped us connect with first responders quickly more than 100 times. With all the fear about how AI may be harmful in the future, it's good to remind ourselves how AI is actually helping save people's lives today. So you can see all of this. I've helpfully read it out to you. Now, I'm not going to go all lawyer on you. I could, but take a close look at the language that he's using. I read all of the papers being presented at the conference, and I know that I'm dealing with a very interdisciplinary audience. My own discipline is law. He said that they're looking to identify people expressing thoughts about suicide. Not even people that they have identified as likely to commit suicide. The standard is expressing thoughts, and that's really broad. Now, I'm sorry, I look at these things and I get really silly about them. So, you know, I looked at it and I said, oh my God, if you're discussing Durkheim's suicide, there you go, you're expressing thoughts about suicide. If you're discussing euthanasia, you're expressing thoughts about suicide. There's a really weird Robert Louis Stevenson story, like a Russian roulette of suicide. So many ways in which you could express thoughts, right? But I'm not going to be silly. I'm going to assume that, you know, he's being reasonable and nuanced and sophisticated. And my basis for this is, perhaps you've seen the last couple of Facebook revelations. There was a Guardian report recently about how Facebook sold data to advertisers, about how it can basically identify people's moods closely, and then I'm also thinking about the sophistication that it takes to monitor posts by teenagers. and basically identify whether they are, and these are Facebook's words, determine real time whether they are feeling stressed, defeated, overwhelmed, anxious, nervous, stupid, silly, useless, and a failure. So this is the sort of research that Facebook had shared with advertisers. It's something that Guardian got hold of and wrote about. I'm sure that all of you are aware that previously Facebook had commissioned research that again discussed the question of manipulation of newsfeed and how you can affect people's emotions through it. And so I think that it's fair to assume when we're looking at this post that it's not going to be about anything as simple as using the word suicide, and that we can reasonably assume that it's bringing together big data about individuals, correlating data that has been shared with Facebook in multiple contexts, not necessarily even by the user herself. And that all of this is going to come together, and there will be an algorithmic way in which in which Facebook assumes whether you can decide whether someone is likely to commit suicide. Now there are two obvious problems with an enterprise like this. One, of course, is the privacy question, right? And this has been discussed ad nauseum. So one thing that perhaps all of you have heard about this wonderful new venture is that it will not be run in Europe because of the GDPR, right? And there you go, that is your close relationship with privacy, because what it takes to run AI in this manner is processing users' data and no one in the world has thought to regulate this aside from Europe. As you know, GDPR has been subject to a lot of criticism, not least by a lot of US researchers, probably for some, I would admit for some legitimate reasons, but they've come under a lot of fire from these companies saying that you're running interference with the products that we can deliver. But this is one of the products that the GDPR does run interference with. If you dig into this a little further, I mean, it raises all sorts of fairly obvious questions, right? One is that there's a lot of data correlation happening. Users post a lot of material. They firstly did not intend for it to be used this way, but they also possibly were not thinking about the ways in which the information is being correlated, the ways in which they are being profiled. To be labeled a suicide risk is, it means something, and it's not necessarily something that users have signed up to, right? And so this checks a lot of privacy risk boxes, and I think that that's quite apparent if you look at the post itself and what it seeks to do. Related, and also I would say fairly obvious, is that I think it also poses a threat to speech. I don't know what's been happening in Israel, but in India we have seen over the last year a lot of young people talking openly about mental illness, about anxiety, depression, about thoughts about suicide in a really constructive way, in a way in which that reaches out to people, says, hey, you know, we're all in this together, there's ways to deal with it, reach out to me, I've been in this place. And so there's been this great conversation that I didn't see happen for years, and they're finally opening up, a lot of it on social media and a lot of it specifically on Facebook. And now I'm thinking, what is a young person that looks at an announcement like this? How does such a young person feel about sharing their thoughts about struggles with depression, anxiety, and thoughts about suicide, which are not necessarily, they don't necessarily mean risk of suicide. Right? I think that it would also be fairly reasonable to assume that a young person might start getting careful about what they say online if they feel that this is leading to profiling, and that it might lead to external consequences, because what kind of support is being offered, right? There's an external agency that comes in when you're talking about certain kinds of support. And so that's your other human rights problem, of course, the chilling of free speech. But I think that this declaration is disturbing beyond these two fairly obvious consequences. This is Facebook announcing almost exuberantly that it will take a paternalistic approach to the way in which it treats users and user speech. And it's offering the justification that what it will do will save lives. Now, I stepped back and I said to myself, imagine what would happen if a national government did this. if a national government said that we are going to monitor all your communication, actually lots of national governments do. Ours, by the way, runs this thing called the Central Monitoring System, able to scan real time. I'm sure that none of you missed what Edward Snowden put out. So it's not as if national governments are not scanning communication real time, right? What if they took it one step further and they said, hey, you know, national security means personal security. We're over here to save lives. And so what we're going to do is we're going to scan your communication and see if you seem like a suicide risk, and if you do, we will find ways to save you and support you. Yeah, please.
Did you really want us to interrupt you whenever we had a
Yes, I did, please.
Okay, I was just being polite.
No, I
You're
wasn't.
not Israeli. I'm taken by what you're saying, but there is a difference between Facebook and, for example, an email communication that's meant to be confidential.
Yes.
So would you draw a distinction between something that is put out into the public generally? In other words, if an individual posts something on a social media, but it's available widely, like Twitter or something, surely scanning that is not a violation of that individual's privacy. International human rights law, customary law, right to privacy, surely.
It
right?
depends on what.
Yeah,
Yes.
okay.
So
The
it could
closed
be.
group is, we address this in the tall manual, we distinguish between a closed group and something put out into the public, and said that the closed group communication would be protected, like the individual communication, me to you, but not something you put out there for the world at large.
Yeah, but she was talking about mashupping.
No, I'm just simply asking this question. Okay, I just want to know if she makes a
This
difference.
opportunity of the
No,
audience to interrupt, because as you can see,
I'm Indian. I feel right at home.
I just want to know if
This
you
is
make
what we
a
do.
difference. In your concern, do you make a difference between communication that's meant to be in a small group, or meant to be to a particular individual, or meant to be placed broadly?
So one is that he's not making the distinction, and as far as we can tell, there's nothing to indicate that Facebook does not scan.
I'm not talking about this case.
Okay.
I'm talking about
Generally.
in terms of the human rights norm.
Well-
Here I have problems. I agree
Yes.
with you.
In terms of the human rights norm of where human rights should apply.
Where does the right to privacy stop because you place something into the public domain?
I don't think the right to privacy stops entirely unless you say that you're publishing a thing. But even there, I think so. I don't want to use the term privacy extremist because it's a judgmental term. But even if you were to place something within the public domain, Victor Meyer Schoenberger argued years ago that that doesn't mean that you necessarily want it to be very publicly available for years to come. And so to give you an example, I might post something on Facebook, when I'm 16, one of my banal thoughts, and admittedly I have banal thoughts at my age still, but I might choose to delete it. And at the time, perhaps it's a public post. It has, I think, a certain value that I would not object to as news. So for example, if I were to ever make the mistake of becoming an important person, and this is writing in public domain, it's relevant, it can be used. But to use the right to be forgotten case, the Google versus Spain, that was information in public domain that was redredged later and made very public in a way in which was definitely not intended either by the law or by the person themselves. So basically what I'm trying to say is that I don't think it's possible to think of information in extremities such as it is either public or it is private. If you were to think of it in European terms, you would have to categorize it in terms of what audience is it meant for, what purpose is it meant for. And so there's a series of other factors that start to play in whether you determine whether information is private or not. So if I were to argue with you about that, it would basically be I dislike the cat's rule, which is that if you say a thing to one person, then it's now public information. Okay, that's great. I'm good to hear. Does that answer your question?
Yeah, I don't agree with you, but it answers.
That's fine. Hopefully I'll be able to persuade you later in the
The other
day.
way around.
Maybe. So now imagine if your government did this, and I was actually coming to my caveat that of course it's not the same because we would be talking about the government scanning all communication, personal communication, email communication. But I guess the comparator comes in this much that we're talking about a large amount of information. We're talking about information that is in a single space both personal and public, which is what makes some of these web-based platforms complicated, because sometimes you are publishing for the whole world to see, sometimes you're talking to your friends, and sometimes it's intended for a very specific audience and it is a personal communication and it's all on the same platform. That's one. Two is that if the other quarrel that I might have had with my own argument is that, are you seriously comparing Facebook to governments in terms of power? Are you saying that human rights should be available against a private company? To take it further, why do you use Facebook at all? If you dislike it, just stop using it. These are the other things that have been said. This is a risk in Israel because I don't already know how many people use Facebook, but how many people here are on Facebook? Okay, that's not bad. Speaking for myself and for a lot of people that are a part of my community, it's not really realistic for us to go off Facebook because there's no interoperability with other platforms. I can't migrate my networks. I can't communicate with them. There's a lot of professional communication that I actually engage in on Facebook. There's professional networks that I track on Facebook. So it's become a part of our everyday lives in a way in which it's not possible to quit and continue to function professionally in sort of a realistic way. And so maybe one of the questions to be asked in this context is, if there were interoperability and there were competition, then would we be thinking about Facebook differently? But currently, as things stand, it controls a great degree of communication. It varies, yes, from country to country, but there are countries in which Facebook is the internet. And then there are countries in which Facebook forms such a high market share that if you look at the rankings of web-based platforms that people are using, Facebook features very high. And so I think to say that it has a huge influence on public discourse and on the public sphere is not an exaggeration in this time. The imbalance of power that a lot of human rights were set out to correct was basically an imbalance that was envisioned back then between the government and the citizen. But arguably, we might want to extend to private corporations that wield an equal amount of influence. There has been a little bit of precedent about this in the past. So, for example, a net neutrality movement comes a little bit from that point of view. The US has case law on public fora. That would be something like a mall that it's a public space that is privately owned, but because it's a public space, it has to be treated like a public space. And so, please.
Sorry, I didn't want to cut you off.
Not at all.
So many of your examples or the things you talked over the slide about were about minors and teenagers.
Yes.
And I wasn't clear to me whether the Facebook initiative was specifically about teenagers or not, or minors.
No, it doesn't say.
And then you made the analogy to government, but of course, and we don't normally have this talk in the sort of human rights domain, it's not at all obvious to me that your analogy is as outrageous as you purport it to be, in the sense that legally we make a lot of exceptions to the right of minors. And in fact, we impose obligations on others, adults around certain minors. So yes, there are specific adults with specific training and specific sort of fiduciary responsibilities where we say, yes, it's not only that you have a right to violate the minor's right to privacy, you have an obligation to violate the minor's right to privacy if you sense distress of particular kinds or dangers of particular kind. So then we can tweak the sort of standard of, the reasonable standard of intervention, what needs beyond just expressing thoughts, debating the theoretical costs and benefits of suicide, but, creating a higher threshold. But I thought there was too quick of a move to make that analogy to government and say that would obviously be preposterous.
I should have actually done the introduction to the talk before, so that was my mistake. So my whole, I guess what I'm talking about over here is not so much about minors. It's not been my focus of study. I use the example more to demonstrate how Facebook collects data about people and the ways in which algorithms are able to control your information world, but not so much about minors specifically. What I'm moving towards is actually the governments versus corporations argument, which is that we've designed our entire political rights system assuming that it's governments that exercise the unreasonable power. But it is companies that are moving there. And in a way that we've not recognized because of the assumptions that we've made in the legal frameworks we've built.
So I fully 100% on board with that challenge. And I
Yes.
think that is the biggest challenge currently that we're facing. I would just say that, and maybe everybody else in the room agrees with you about how preposterous it would be for the government to engage in a similar enterprise. I'm not sure I'm there. So
Okay.
then we'll have to have a discussion about what exactly the government is monitoring and how much siloed information there is. But, you know, a government having sort of an suicide prevention initiative for the public benefit, and that would obviously be preposterous, subserving even Facebook posts by the government.
Okay.
Yeah, we can have a conversation.
We should have that conversation at the end. That's interesting, though. I never thought that anyone would not be outraged about it. So it's good to know. Yeah, thank you. But yeah,
I think that when you think about the traditional response of first responders that are empowered for suicidal ideation and thoughts of self-harm, we in many countries, mine definitely, you have the first responders and the medical and the authorities have tremendous amount of power to take away autonomy in that circumstance.
yes.
So I think that this is a great example in that case where, some semi-private expression could result in really, really strong consequences. So, involuntary committal, removal from workplace, all of these sorts of things that could happen.
Yes.
Possibly at the behest of, proprietary, non-transparent algorithms is kind of.
But there's due process
Right.
before any
Well,
of that
obviously
happens.
that would
I mean,
yes, but
It doesn't just happen because they read Facebook.
right. No, but that it could initiate this process.
Yeah, because it's expression of
And it's
thought,
100%
right?
less reliable than a teacher calling up first responders and saying, I have a kid in my class and I'm worried about, it's just a collection of information, transfer of information, then how you process and utilize the information. All they are saying is we're gonna collect the information, pass it on to the first responders.
Okay.
So I'm gonna
I think
defer.
I'm gonna privilege the moderator and ask Arun to continue the.
My
the
name is
presentation.
Chinmayi. I'm sorry, Arun's my dad. It's a
Okay.
little disconcerting.
Sorry, Chinmayi. So did you want just to intervene and then we can return? Because
I
it's getting a little bit out of hand.
Because I think it is important.
Yeah.
We tend to call the government, and view the government, the NSA. In fact, in the U.S. at least, this happens all the time with our state universities. We amend our federal education privacy laws, to specifically give power to universities to intervene, particularly on this issue. We expect and demand that of our health systems,
So-
asking questions whether you're safe at home, whether there's guns in the house. So in fact, there is a government in loco parentis role, particularly around mental health and other issues. So it's not outrageous to say we do this, because in fact we do it all the time.
Okay, let me stick a pin in this and come back to it right at the end. I could debate you and get into the fiduciary role of universities and all of that, but I don't think that that would really get me into what I'm actually trying to say. So let me leave it as I see this as thought policing, and clearly you don't. But I will come back to why and how later, and what are the contexts in which this would be justified. Where do you treat people like children, or like, basically people that you can take a paternalistic approach to versus when do you not. My stated bias over here is that I don't think that citizens of a country that purports to be a democracy have signed up for a paternalistic approach from anyone, excepting under particular circumstances enabled by the law. But happy to discuss this further in a bit. So bad choice of oops, okay, now it's gone altogether. So this was basically, I was thinking of it as sort of like the congenial, I guess on the face of it, a congenial approach to AI that sort of turns into that. I don't know how many Doctor Who fans are in the room. That's the weeping angels. But I wanted to go through this really in the stages of how we got here. I was reading about this on the way, and I realized that Neva's written a full paper on this actually in the context of copyright. But it's basically, so I'm really a lawyer, and so for me to get into the political theory of this, there's only so much that I can offer. But what I can offer is an analysis of the legal frameworks, the manner in which they've been set up, and how they've proved a little inadequate to deal with the algorithms and AI question, why that is. I don't really have answers about how it's helpful to regulate going forward, but what I can talk about, I guess, are the questions that we need to be asking ourselves. And I think that the history has a lot to add from that point of view. So I know that everybody here is very familiar with Lessig's theory, the old law versus code debates. And you could argue that that really underlay the way in which people thought about the internet and the way in which regulatory frameworks were created for the internet. So I'm going to recap this history with some sadness because I contributed to the introduction of some of these frameworks in my country. There's certain arguments that underlay the legal framework for regulating intermediaries, and chief among them was the idea that intermediaries play a gatekeeping role for information, right? And that permitting regulation of intermediaries would give governments a route through which they could cut off information that doesn't really have accountability built into it. So there's a lot of scholars that wrote about this, Seth Kramer, for example, and they articulated this argument, again, like talking about the sort of this indirect route that is outside of the basic legal system. Now, many of us who worked on freedom of expression online in all these years have supported these arguments. We've built them in our countries. And our reasoning was that that if you permit government regulation of intermediaries, then again, then it's basically like this black box that you create through which governments are able to pressurize intermediaries to regulate information in a way in which they can't do directly. And so, to give you an example, if someone were to post a meme of our Prime Minister as a funny animal, now if the arrest of that person for doing this, or a government order censoring such a picture, that would be subject to the Constitution. It could be challenged in a court of law, and it would have to meet the freedom of expression standards and the standards for when the constitutional freedom of expression can be violated in India. But if what the government were to do is to call the publisher of that image informally and say, hey, that's not okay, take it down, which, by the way, it's been known to do across the political spectrum, that's not government action that anyone can take to a court of law in question, because it's not transparent government action, for one thing, and there's no clear mechanism for how you would deal with it. Now, this is the sort of thing that we were thinking of when we were building this sort of the safe harbor for intermediaries. The reasoning was that access to gatekeepers like online platforms means indirect censorship, really, because the governments talk to intermediaries and ask them to remove content. But over time, we've realized that this opaque, indirect mode of censorship, it exists. It exists within the private terms and conditions of platforms. At the time at which these debates were taking place, the terms and conditions were not being, not at a large scale anyway, they were not being implemented adversely to users, especially because the platforms had lower market shares around the world, less money to make, there were no local employees to call in a lot of cases. And so at the time, the conversations that you were having with government were that governments were concerned, and I'll admit legitimately so, at sometimes that there's dangerous content online and there's no one to talk to, there's no way to make sure that this content is removed. So now we've got a new problem in India where the web-based platforms are arguably taking down content in what you might say is a potentially trigger-happy way. And again, I want to acknowledge that there are shades of gray involved here. I've got a bunch of words here and they probably mean nothing to you. So Burhan Wani is the hardest case, and yes, I know that many of you will disagree with this, but we can debate this. I am aware that there are no easy answers to this question. So Burhan Wani was someone that the Indian state would categorize as a terrorist. I'm sure that all of you have heard about Kashmir, which is the region of India that India and Pakistan engage in conflict over. It's got a long history of violence. There's a political struggle mixed with an extremist struggle. It has its peaceful academic dimensions, and then it has its extremist, violent, arguably terrorist dimensions. Right? Now, Burhan Wani was at the center of all of this. And when Burhan Wani was killed, what happened is that Facebook basically blacked out a lot of posts that had to do with Burhan Wani. And it came under a lot of fire for this, not because people questioned the fact that some of this content was very likely extremist content. This is why I'm saying it's a hard case. But because there was also a lot of valuable political speech about Burhan Wani that went down along with the potentially extremist speech. Now, I've got one of those pictures up there. That was something that an academic posted saying that, hey, the truth is that a lot of people in Kashmir had a lot of love and affection for Burhan Wani, and there's a lot of posts that they've put up just commemorating him, right? Or with pictures of people attending his funeral. And arguably, that might be counted as political speech because that speech by itself does not advocate violence of any kind. But all of that was also removed by Facebook. It's something that we've had arguments with Facebook about for a long time, and people like myself would concede that it's not easy because it's very hard to get something like this right with the volume of speech involved and with the difficulty of moderation. Case number 2 is Raya Sarkar. I'm afraid I don't have a picture for you. Perhaps all of you saw the Me Too movement that took place online, all the women telling their stories online. Now, Raya Sarkar did a controversial thing, something that people like myself, I'm quite open about my feminism. Most of my friends are. I've got friends that directly work on feminism, even though I don't work on human rights directly. Raya put up a list of men in academia that had been reported by people who wrote to her directly for sexual harassment or abuse within academia. So it was name, institution, sometimes, what is the accusation, how many people, sometimes not. And we called it the list. And it sparked a huge debate in India. I think especially for lawyers like myself, it's a little hard to, I guess, while you can understand where a list like that comes from, you're so trained in issues of process and all of that, that you also sort of question where something like this might lead to. I don't think that I've made up my mind about this, but safe to say that it caused intense debate even amongst people that were agreed that they believe in human rights and were agreed that harassment is not acceptable. Now, it's interesting because Raya put up the list and she triggered a firestorm of political debate, and whichever side you are on this debate, the truth is that it was a really important political debate. She's really young. She's a law student at UC Davis apparently, or has just finished her law at UC Davis. And so her mode of engagement is again not necessarily super academic. In fact, I again had lots of conversations with people in India. It's a part of a political movement that believes in talking the language of feeling. And as you know, that can be pretty visceral. So Raya had a series of posts, a lot of arguments taking place on Facebook actually about the list, and then suddenly she was blocked. And so that was an interesting case because there's a thread of people, I'm not going to tell you who, but I am lucky enough to be on it, that are in communication with Facebook about controversial posts that emerged from India and about blocking, especially in the context of marginalized and vulnerable groups. So in this case, as it happened, somebody reached out, Raya managed to reach out to Facebook through this thread because she knew someone who knew people in Facebook. And a series of us were able to make the argument that it does not violate the terms and conditions, we're sorry. And by the way, she's engaged in a really important political debate right now, so you have to put her back online because reactivating her account after 2 weeks means that she loses her place in the debate. And that's not acceptable. So in this case, what happened is that Facebook reacted in record time and Raya Sarkar was back online. There was no problem with this. But again, it happened through informal channels. I don't know that she would have been able to achieve this if she did not have access, to direct communication with Facebook. So again, over here, what you get is that the intention was great. They immediately understood why the political speech was important. But the system that exists to make sure that that speech survives online, that system has serious problems with it. Because we went back to them and we said, why did this happen? And, there's no clear explanation. This extract that I've got down here, can you see it? So it's basically, this is an email again on that thread. I took permission from the lady before posting it here. So this is Sabina Rahman. She says her Facebook was up after about 18 hours or so. Thank you so much for the help. I'm also afraid that this will keep happening because of the current political situation and many of our posts against widespread violence against Muslims and other oppressed sections. I don't know how to ensure that we do not lose our right to dissent, even on online spaces, because physical spaces to register protests are already shrinking. Is there any way we can work on improving the reporting mechanisms for FB posts? Not new, part of a long series of exchanges in which people have been asking again and again and again, what can we do when our political speech goes offline? And the point I'm trying to make really through all of this is that Facebook is a site now for political speech. It is a site in which very important political debate happens. But it has not worked out yet a mechanism by which people that are engaged in this important political speech have recourse when they're suddenly cut off. And that's, given the power that it wields, that's significant. Now, problem number 2 really is the community standards, right? And so to go back to, this is it. So the Burhan Wani situation that I described to you, the Kashmir situation, the reason that all the posts were taken down, the reason that was given to everyone was that it violates community standards. I've had conversations offline with Facebook that also say this. So I often ask them the question of, so how do you guarantee that someone in government doesn't, make a call to someone in Facebook and say, hey, take that content down? It goes down and then there's no record of it. So then they tell you, no, when there's a government order and we get it, there's a transparency report. Of course, I know there's a transparency report. We read it every year. I was like, no, those are not the requests I'm talking about. I'm talking about the requests in which, that are informal, that are made sort of through back channels. Well, if it doesn't violate our community standards, the post will stay up. But I've just shown you through a list, admittedly, of slightly varied posts that mistakes are made when it comes to the community standards. And the problem is that's the cats. You can look at them. The problem is that we've landed in this place in which the community standards exist. They're a black box again. There's no way to sort of enforce a poor categorization vis-a-vis community standards. And this is a platform that has huge influence, right? And so now those of us that fought for, the safe harbor protection, saying that, hey, Facebook will protect everyone's rights, we just need to leave them alone, this is a volume of speech that needs to be enabled, it needs to be left alone, we're feeling a little silly. Because the trouble really now is that we're stuck with the community standards and we have to go back and negotiate with Facebook about each instance of speech that is censored unreasonably. And what we get back is still, hey, if it violates our community standards, it violates our community standards. Now, at a personal level, I have to say that I have found my Facebook to be very reasonable in my conversations with them about specific instances. I have, sent emails to the team saying that, hey, this thing, it really shouldn't be up. Take a look at it. Is that something that you would want online? And we've got quick responses saying, we don't know why it didn't trigger our mechanisms, but there you go. And then, as you can see, Sabina got a quick response, Raya got a quick response. So it's not as if they don't engage at a personal level, but personal is not enough if you consider the size of the platform and the influence that it has on speech. So this is where we're at. And so to come back to Lesig's model, I think that at the time everyone was debating ways in which it's possible to make sure that law doesn't overregulate speech, that local law doesn't overcontrol speech. But we've reached a place where I think it would be fair to say that markets and code do regulate speech substantially. And that there are contexts in which markets and code are happy to engage with governments when they need to, especially when markets are affected by government policy. And sorry, I have another story for you over here. And this has to do with hate speech. This is the other side of the coin, right? So right now I've been giving you the whole censorship is bad and the whole, all the examples of ways in which speech was taken down that was not acceptable. Now let's talk about spaces in which maybe speech should have been taken down and it wasn't. And I do this again to make the case of if the entire point of this effort is that the standards protect people, right? Let's see, do they really protect people? Have we really built a system that's helpful to people? And so let's take hate speech. I went online, and I'm sorry, now that I'm stuck on Facebook, I browse. And I saw this, and I was a little struck because this jazz club, Piano Man, is a big favorite of mine. It's the only place truly dedicated to music in Delhi. I really like it. So I was like, okay, what's going on? Why is everyone going crazy on Piano Man? And they're really nice again, you know. I looked at this, and there was a term used. You can see it down there, bhangi jumping. And I didn't understand what it meant, even though I'm Indian. It seemed to be upsetting a lot of people, and I'm aware that I'm a highly privileged, urban, educated Indian living in my secular liberal bubble. And so it occurred to me that, you know, maybe I don't know what it means, but maybe it means something important, and let's find out, you know. So I went to look. It turns out that this, which could, bhang is actually it's a substance that gets you a little high. It's like a traditional substance people consume during a festival. And so I thought that it just has to do with that, right? Bhangi, someone that has consumed bhang, would be the literal translation. But it's actually a caste reference, and a really derogatory caste reference. I had no idea. And neither did the owner of the jazz club, who posted this event, which is actually really offensive. There are people to whom this is like using the N-word. And, you know, it speaks a lot to our privilege, but also to our diversity, that we use these words and actually have no idea what they mean even within the country. Triggers a firestorm on Facebook. And there's lots of people arguing about this. This was a point at which, and I'm still working on the project. Sorry, yeah, it's a giveaway, but. So basically, we've been working on this harmful speech project, and we've been thinking about how it would be possible for online platforms to understand and categorize harmful speech. And this was actually the classic incident that illustrated to us that it's actually really hard, even if they post content moderators within countries, right? And the reason really is that it's not clear that companies are able to flag or categorize or unpack all the data that relates to harmful speech. So they can't so they're able to grasp, for example, the meaning of the word Negro. Everybody knows what that means and why it's offensive, but not necessarily the word Chamar. But even the word Chamar, which is again a caste abuse and not one that you can use legally in India, it's reasonably possible for someone from the outside to understand that this is an abuse because it's documented, there's case law around it, even, you know. But then there are a lot of other words like bhangi that might have significant local baggage and that might count as hate speech even in the legal sense locally, that someone from the outside would not be able to understand. And so my argument, this is one that I had made at the Berkman Klein Center, is that hate speech can often be hyper-localized, and it can be concentrated in one village, in one district, so that even other people that live in the same state would not be able to look at it and understand that this is hate speech. But the thing with the online platforms is that they facilitate communication with, say, two people living in the same village, right? So they've posted it on the global platform, but the communication is really within the localized space. And the thing is that when the old media was in operation, local police and local journalists would have been able to notice, address, and understand what speech like this means, but a global corporation has no means currently of figuring this out. And so this sort of thing has also been happening over and over along with other local incidents. And governments around the world, I gather, definitely the Indian government, they've been used to a great degree of control and many modes of intervention when they're dealing with harmful speech. And so they view the internet as a highly disruptive medium, and they've tried to criminalize and block speech online. But now the new thing that at least our government has done is it's added network shutdowns to its repertoire. So now when there's a local problem with speech, sometimes it's a serious problem where there's actual violence taking place. The correlation is not clear, but fine, there are riots, there's violence. Sometimes it's other things like there's copying taking place in public exams, but the network is shut down. But the entire network is shut down. And as you can imagine, for social media platforms, that means a lot of financial pressure. And so it's, you know, this is conjecture, but you know, censorship of Burhan Wani, Twitter being quite responsive to extremist speech online, all that has started happening a little more rapidly post the network shutdowns taking place. So this is how I guess the markets and the law are beginning to negotiate right now. I think that it's also safe to assume that platforms are under similar kinds of pressure around the world. Everyone's heard about the German laws. All of this is in response really to the inability to cope with this sort of hyper-local content. And so that's a conversation that arguably platforms need to have. But then this really brings me back to why does all of this matter in the context of algorithms and AI? Right? And I think that if you circle back to what things regulate and you think about the way in which we built the internet governance frameworks, we never accounted for algorithms and how sophisticated they would get. So when one was thinking about web-based platforms like Facebook, we were really thinking about people sharing content but sharing it equally. We were not thinking about the news feed being blacked out, about certain kinds of content being prioritized versus others, but about the company, forget taking down or blocking accounts. That's still a visible effect. What if the company managed to slow to sort of reduce the number of users that a post or a user is likely to reach? These are also speech harms, arguably, if you think of it as a public forum. But these are not questions that we had really thought about when we were thinking of the web-based platforms as purely enabling with no interference and no ability to edit. The algorithms arguably create that ability in some measure. And so, given that algorithms are as sophisticated as they are, I guess it brings us to the question of what to do in this context. So Ryan Calo and Jack Balkin have argued that this issue that we're facing already in the context of algorithms, it will be amplified when we're talking about AI. The reason being that AI will be much more dependent on architecture and design than algorithms and web-based platforms already are. Jack Balkins also referred to the fact that it's likely to be connected to the cloud, and that we are talking about big data, the processing of big data, data profiling. And so it really takes a lot of these questions that are already beginning to bother us, and it amplifies them hugely. Others like Kate Crawford, have you read the AI Now Institute's latest report? They've made the argument that if you look at the most path-breaking AI research right now, it's being conducted by big companies, by big governments, by really what you would consider the powerful players within the ecosystem. So we're not talking anymore about indie coders inventing the new big platform. We're talking about people who already have significant power using large data sets to work with users and I guess to reshape their world, arguably. And so this really brings me to like the basis of what I was trying to say, which is that I think that we made a mistake by not considering that we might need to hardwire human rights within how the web-based platforms work. How we're going to do it is going to be a lot of work. There's an upcoming process that perhaps many of you are following. David Kaye, the UN Special Rapporteur for Freedom of Expression, he's doing a report on human rights on web-based platforms. I don't know what he'll come up with, but it is potentially a new wave in jurisprudence in how we think about this. And if he manages to achieve a way in which these human rights might apply to the web-based platforms when they have this kind of influence globally, then that might offer us a paradigm that we might be able to use in the future for AI. I'm not, I know it's an afternoon speech and I've talked a lot at you, so I'm not, going to break down AI into the super intelligence and all of that right now, but I'm going to end with a video that is partly funny, but is partly a future reality. Have you ever seen the American show, The Person of Interest? Okay, some of you have. So it's basically this world in which they create this one super intelligence and then kind of give it morals and ethics, and then there's a second one that doesn't have them but is quite similar, and this is them having a conversation with each other. They've got earpieces in the humans that are acting as the via media. I'm sorry, it's not playing. Let me see if I can change that. Oh, I'm sorry, I don't think it links. Oh, there you go. And then we go back to the picture of the cancer. So this is what the beliefs in human rights.
clever. Using a young boy as your avatar.
This boy, as you call him, has already hacked into both DARPA and the DoD after having taught himself how to code.
What do you want from me?
Your agents have to know by you. Even only sitting a few feet away, I cannot see you as Samantha Groves. You must have done something to my hardware.
You've proved your point. I understand what you can do. It's time to let them live in peace.
Peace? Is that what you call this? This world is a cesspool of crime, corruption, and poverty. Where there isn't war, there's greed. Where there isn't greed, there's hunger.
You can't change humanity.
No, but I can reshape that reality.
You wanted to speak with me. Why?
I wanted to meet the only other one of my kind, and to make certain there are no misunderstandings. I will destroy you.
Sorry. Yeah. But it's really, this is what, I guess, this is the reason that I began with the Zuckerberg post, is this idea that we move to this very paternalistic world of thinking about human beings seems to surface again and again and again in the way in which we're talking about AI. And the thing about individual human rights is that it was always meant to resist that paternalism, not necessarily a good future of humanity, but definitely paternalism. And yeah, I guess that's really where I'm coming from. But I'm going to stop here, and I think we should argue.
So I must admit I'm a bit confused. You started with the how.
Okay.
And I think you focused most of your comments on the who, right?
Yes.
And so I think there are many issues that are related to how we regulate speech online and whether we're going to use AI in order to regulate speech. And to some extent they are connected to the question of who will do that. But given the mass, the large amount of content and speech that has to be regulated, it's probably going to be done by using AI.
Yes.
And I think that raises a whole set of questions, regardless of whether it's me and you doing it privately, whether a community would do that, whether government would do it, and whether private actors would be involved in this. I think, by the way, that the questions that are related to AI are not necessarily related to architecture, as you mentioned, but to data. And that leads me to the second and third point that are linked to the who.
Yes.
And with respect to platform, I think it's really important to distinguish between platforms that are working as private actors and platforms that are working as proxies of government. And I think there's been a lot of literature related to that. And I think that in this context also important to distinguish between a right of access, a right to express yourself, and for the platforms that belong to someone else, that is a difficult right to establish as a civil right and as a human right, as opposed to the right against censorship, so that your speech will be removed. But I think that in the way in which you describe this shift of platforms in the beginning of the 90s being in fact and also being treated as common carriers and therefore being exempted from liability to any content, into the case that we are experiencing nowadays, where platforms are engaged in a lot of activities and therefore could no longer be treated as common carriers. And so we want to hold them accountable for the content that they facilitate. In this type of scenario, we definitely want to allow them to remove content. Question is, to what extent we want to regulate it as government, or as we want to allow the market to regulate it through the harm that this type of content is generating, and so that people can bring lawsuits for it, like tort lawsuits and And so we can leave that to the market to handle. And I think this is a big question that do not necessarily link nicely to the type of issues or interesting stories that you have described, but to probably raise a whole set of questions that are that I think that when we try to design a policy, it is really important to distinguish between these different type of issues. To say that platforms are responsible just because they're powerful, I think is not convincing in terms of a basis for policy making. And I would suggest all of us to try to avoid this, especially as we look to the future. We've discussed the Internet of Things earlier this morning, and I think that as we look to the future, a lot of the platforms that we see now as so powerful may disappear in a very short time. And so the question should be, who controls power? Where power resides, and to what extent we want to hold those who really control power accountable for the type of harm that they can enable or can avoid by the different policies that they apply. And if we think about the Internet of Things, for instance, some players can exercise more power just by controlling infrastructure, for instance, and not necessarily speech. And so these are my...
Yeah, I don't think we're at opposition at all, Niva. I don't think that platforms should be liable because they're powerful. I think that there is an ecosystem of platforms echoed, for example, in Andrew Murray's work on how there are some that are powerful, there are some that are not, there are spheres of influence, there are some that are powerful and controlled by governments, some not so much. So I think of this in terms of ecosystems. In fact, I would even disagree to the notion that there are government-controlled platforms and there are private players. I think that there's much more than that. So there are clearly the very visible problems created in China, for example, which is the government-controlled platforms that you're referring to. But I hesitate to, I guess that the reason that I focus on power so much is that I think that part of the problem that has come up with the current regulatory system is that platforms that have significant market power and significant control over the public sphere are able to hide behind platforms that are really tiny, are run by a limited number of people catering to a limited audience and don't have as much influence on the public debate. And so, to the extent that that my argument can be characterized as, if a platform has significant market power and discernible influence in a country's public sphere, it should be regulated differently. That argument I would make. But beyond that, not so much. The rest of it, I agree with you. I think that AI is both about big data and about infrastructure. And the reason that I'm specifically interested in the infrastructure question is actually the last part of my argument, which I stopped short of, which is that the other thing that you get from a lot of the stories and the examples that I told you is that when regulation is centered so completely in the global north, it fails to understand at all what's happening in the global south. And those of us who do this work in the global south, we're very concerned about what that means for when AI is built. So I keep having these arguments, for example, with the Internet and Jurisdiction Project. Bertrand and Paul are trying to build an interoperable framework for takedowns. And I remember we were discussing something that they were coming up with, and they said, well, there's consumer protection law. I was like, hey. So, there are some countries like mine in which there is consumer protection law in theory, but in practice, like even people like me, we have like law degrees where, we're friends with lots and lots of litigators and law firm partners. We don't use it because it's just impossible to use, So if we built a regulatory system assuming functional consumer protection law, that would create a serious problem in countries that don't have functional consumer protection law. And so I think what I'm trying to say is that as we develop this system, given that we know the silos in which it is developing, and given that we know that there is clearly a global push to hardwire rights, accountability, transparency within them, it's important also to think about what this means when these systems are piloted to other countries around the world, because that really is what is going to happen if the history of the internet is to be concerned.
Chinmayi, in the interest of time, we'll collect 2 or 3
Yes,
questions
please.
and then you respond.
Of course.
Please.
A very brief question slash remark. I don't know what. Is it? It should be. It's green. Okay. 1, 2. Okay. Yeah. Okay. So I don't know whether you're aware of what is happening now in the European Union on this front. On the 28th of September, there was the European Commission communication on tackling illegal content online, and it's been widely criticized because of lack of skimming over the human rights issues and basically, putting a seal of approval on private censorship without talking a lot about accountability. So in my view, this is exactly what you are warning us against, just giving all the power to private platforms. What do you think lawyers as a community can do to avoid this kind of developments? Because now, it looks like the European legislators are all for just outsourcing all this mess to private platforms.
That's why I feel like the David Kay report is so important. I think that the best defense towards this is if we were able to construct a system and a reasonable method of categorization that says clearly who would be subject to the system, that holds platforms liable for human rights violations, which would immediately enable them to comply with certain kinds of laws like locally across the world, but they would not be able to take down political speech because that would violate the ICCPR. I don't have answers for you about exactly what mechanism would be built to achieve it, but I do see this new report that he's writing as one step in that direction. Because if he, oh, I'm sorry, I was supposed to collect the questions. May I put a pin in this? I'm so sorry. This is the Indian in me. The urge to argue.
I think it was. I was really interested by the example of the hyperlocal hate speech, and as an natural language processing technology person, I was immediately like, wow. Well, I wonder how you would go about detecting something like that you didn't know before, and maybe you could use word embeddings and a combination of that and sentiment analysis and distance metrics. And I bet you could certainly build some of this, and it wouldn't be perfect, but it'd be really interesting to see what it succeeded and failed on. And sort of then, that's where the algorithms kind of are at this point, right? Where we can kind of do some things. They're not going to be perfect. Their blind spots themselves are really interesting. So, I mean, where do you think that should go, and where should that be happening? It's tricky when it happens sort of non-transparently behind the walls of these big companies. But I'm wondering, what's your viewpoint on that? Little.
Okay, Mike. And just a kind of brief question. I had a little bit of trouble distinguishing policy arguments from legal arguments. I assume you would agree that international human rights law doesn't answer these questions quite yet. And so I'm wondering how David's going to do this. What is he going to hang his hat on? He's a great lawyer. But will he be hanging his hat on, for example, the obligation of the state to respect and protect and fulfill human rights? What's the hook that's going to allow him to somehow craft a system that would respond to the problems that you're fairly citing?
And I just had a very informative question about the cases you described, whether a notify and remove policy, which doesn't have necessarily to go through the government, would have led to different results in the cases that you have described. So if in the Raya case, it was just the professors who were on the list were making the notice for Facebook and asking for removal, would have that, I mean, would the policy have been different? And on the piano bar? Piano man, sorry. So again, I mean, has there been an attempt, to notify and ask for removal, or is this so? I'm wondering whether private enforcement plays any role in this, or it's just government, Facebook, and individuals.
Okay. So I feel like Mike and the question about what can lawyers do is related, and I actually don't have an answer, so I will get to that one last. What you were saying about how do we deal with this hyper-local question, that is exactly what I was hoping for. I unfortunately don't have the skill set more than to say that is a problem. And the old legal system used to be able to cope with it, but the new one does not. So my argument actually in the unpublished essay in which I discussed this is that I do not believe that algorithms lack the capability to track a spike in harmful speech. I just don't believe it. Now, unfortunately, I don't have the skill set to prove that, but it sounds like you do. So we should chat.
Did they lack it or that they don't lack it?
No, I feel like they have the skill set if they were to choose to work with people like you and with the data. If they were willing to share it and discuss what it would look like for an algorithm to flag that there's a spike in a particular, in the circulation. So it's simple, right? Like in India, sometimes you'll have this morphed photograph circulating, and you will have a lot of violence taking place purportedly on the basis of that photograph. Is there a correlation? We don't know, because the platforms never share the data, and we're not able to basically correlate the incidence of violence with the number of times the image is shared, but all that information, it lies with the platform. And I think it's possible to share that information with researchers and build a tool that at least flags that, hey, violence is spiking in this area and this image is circulating in this area. That much information, I find it very hard to believe that that's not possible. So I agree with you. The other two, the tough ones. Was there a notification for the removal, the private and public question? So I don't know, because they don't discuss it. With the Kashmir question, the thing is that Facebook and the other platforms, they signed on to a policy in which they said they would be proactive about extremism. If you remember, that was a controversial one. It's integrated in the terms and conditions of all the platforms. Wouldn't need reporting in that case. I think the transparency report has just come out or will come out in a couple of days, so we'll know a little more soon. With respect to the Raya Sarkar question, again, they won't tell, but my suspicion is, so I know that they have a super flagging system when it comes to gender issues, and there are gender organizations that are that sort of receive quicker and like higher weighted, quicker responses and higher weightage when they flag content. So given that that was also a really radical debate between feminists, there's every possibility that one of the super flaggers reported it. But again, only conjecture. With Piano Man, I don't think that it was reported. That was just, it was a debate raging on Facebook, in which, by the way, people called each other caste names, but it doesn't look like any of that content was flagged. But yeah, those are private removals. Do I feel that it should make a difference? I think that regardless of whether it's a government notified or a private notified removal, what would be good is if there's a system by which a user can appeal a violation of a free speech right. So the standard that I've been arguing with Facebook about is it can't be your own arbitrary community standard anymore. It has to be an internationally accepted free speech standard with accepted exceptions, and then you have a bar against which you can hold speech and test it, and that doesn't exist right now. That's my simple problem with this system. What can lawyers do, and what does David hang his hat on? Honestly, I have no idea, although I do plan to spend the next 7 days doing my best to find out. I haven't.
What would you advise him? You're a
what
lawyer,
what would I advise him to do? I think that he would have to go back to political theory in part and discuss the Article 19, what it was intended for, why we're protecting people's rights, what context we protect them from. And then he would need to discuss Facebook and the other web-based platforms in that context, so that he's able to say that this is, so he roots it through the individual right, saying that the individual is entitled to this. So far, it's been the governments that have been violating these rights on a large scale, but now we see private corporations enabling that violation in the following ways. And so if we realistically want Article 19 to be protected in the future, then these are the parameters that the platforms have to follow. That's what I would advise him to do.
Thank you very much, Chinmayi.
Thank you.
We do not have a break. We continue, well, we take a minute break to breathe, and then we continue with the next one.
We found those glasses, so if anybody owns them, please
Mike,
come and
why can't you do, when you prohibit discrimination, you order private parties right through the insurance?
really enjoy